So I would like to welcome everybody for the Friday webinar series that has been launched by EGROW Foundation. As you know, the Foundation for Economic Growth and Welfare is a policy-oriented research tank. The policy-oriented research tank means that we believe in research-oriented policy and research-based policy advice. It is in this context that for the last 1 year, we have invited the best minds from across the world, including two Nobel laureates, to come and speak to us on contemporary issues. Continuing in the same tradition, today we have Chairman of the Prime Minister's Economic Advisory Council, Dr. Bibek Debroy, speak to us. To chair the session today, we have Dr. Arvind Virmani, Chairman of the EGROW Foundation. Dr. Virmani himself has worked in policy issues for nearly 3 decades. He's spent long years in the Planning Commission. His areas of research have been very wide. He was also the executive director at the International Monetary Fund, Washington. He has published extensively in refereed journals and has a number of books and book articles to his credit. With this, I hand over the session to Dr. Virmani.
Thank you, Charan. As Charan has already said, and all of you know, Bibek is the chairman of the PM's Economic Advisory Council. Before I say a few formal things about it, I'd like to talk about the current topic. Vivek is the expert on legal and institutional matters who I first consulted when I got into this subject 20 or more odd years ago. And he was the best authority, and he referred me to his articles and the data and so on. So he is really the best expert we could find on the connection between law and economics. And his topic today is very relevant, the legal system and its impact on growth. With that, let me just give a few of his achievements. Of course, he is chairman and he's been in Niti Aayog since its inception. He has won many awards, and I believe, I didn't know this actually, Padma Shri in 2015, is that correct? Yeah, and Lifetime Achievement Award of the US-India Business Summit. He has worked on game theory, economic theory of income and social inequalities, poverty, law, of course, reforms, railway reforms, and many other things. He has also written several books on various topics. With that, let me invite Dr. Bibek Debroy, a very old colleague and friend, to give this talk, for which he is really ideally suited. Dr. Debroy.
Oh dear.
Can you hear me now? Can you hear me? Okay. I said thank you, Dr. Virmani, and let me start by thanking EGROW, Dr. Virmani, and Professor Charan Singh for having invited me to talk on a subject that's very dear to my heart, as Dr. Virmani mentioned. And good afternoon, ladies and gentlemen, wherever you may happen to be. I shall begin with 3 anecdotes, because quite often anecdotes drive home the point. The first anecdote goes back to the year 1993. In the year 1993, the finance minister was Dr. Manmohan Singh. There was one particular economist, now dead, so I shall not mention his name, who was going on a UGC-sponsored trip to Paris in 1993. Because it was a UGC-sponsored trip to Paris, there was a per diem. In those days, the per diem ceiling was $65 US. And he knew Dr. Manmohan Singh as finance minister, so he shot off a letter to Dr. Manmohan Singh saying, look, this per diem is $65 US. You cannot survive in Paris for $65 US. Can you possibly increase it? So files started, and Arvind is familiar with files in the government. And essentially the file went up and down and up and down, and the question was, why should we unnecessarily increase the hike the per diem only for why should we hike the per diem only for this particular gentleman? If we are going to hike it, we should hike it for everyone. All right? So where did this hike come from? And it transpired this hike emanated from a certain section of FERA. So as I said, it went up and down. So a question was asked that why do we need this section of FERA? And a subsequent question was asked, why do we need FERA at all? And the then Finance Minister, Dr. Manmohan Singh asked, that all right, why are we only talking about FERA? Surely there must be other pieces of legislation that are also impeding economic decision making and enterprise. Why don't we set up a project to take a look at all of that? Hence, in the year 1993, I got dragged into this project known as Legal Adjustments and Reforms for Globalizing the Economy or LARGE, which is how my interest in law reform partly started. So that was anecdote number one. Anecdote number two is, LARGE had a very small office, and a lot of the work was done by people, including lawyers, sitting in their own offices. And one of the tragedies, I believe, in India is that the proper law and economics interface has never really happened. Economists, by and large, do not appreciate the law, and lawyers, by and large, are not interested in what economists are interested about. In the United States, as most of you know, there has been a thriving law and economics movement, a thriving law and economics interface that has not existed in India, has not developed in India. It's only beginning to emerge now. All right? So several of my friends were lawyers, and I went around asking all the lawyers I knew, what is the longest case in India? And no one had the foggiest idea. No one had any idea of what was the longest case in India. I myself started tracking a case for which the last hearing was held in Calcutta High Court in 1905. After that, I don't know what's happened to that case. So I modified my question and I said, all right, I'm not interested in open-ended cases. What is the longest case in India that has been concluded? No one had an answer. Then I looked up the Guinness Book of World Records, and I found the Guinness Book of World Records said that India had the dubious distinction of the longest case, a case that started in the year 1205, ended in the year 1966, so it took 761 years to be resolved. And this entire case involved an ancestral family shrine in a village near Pune, and the family broke up. So the question was, which branch of the family would have the rights to perform the worship? It did occur to me 761 years was too long. Legal jurisdictions had changed, regimes had changed. Nonetheless, it was bizarre, so I started writing about it. Where some months down the line, I get a letter from a gentleman in Hyderabad. And he says, dear Mr. Debroy, these were the days, remember, there were no faxes, emails, it was mostly, well, faxes existed, but it was mostly snail mail. He sent me a letter saying, dear Mr. Debroy, I've been writing about this case. Have you looked up the court records? I said, no, I haven't. Nothing happened for some time. And then in the mail, I get 4 sets of files, photocopied, And these are lower court records. And he sends this to me, and he says that if you look at this very carefully, you will find that the actual case was started in January 1964, ended in December 1966, so it took less than 3 years. In the course of the obiter dicta, which of course is not part of the main judgment, the judge said the roots of this can be traced back to 1205, which is quite different from saying that the actual case had lasted for 761 years. I hope you will not write about this case. So I wrote a polite reply saying, thank you very much. I stand corrected. I will not write about the case. Will you please tell me what was your interest? He went to Pune, photocopied these, took the trouble to write to me, and he said, look, now have the distinction, dubious distinction of the longest standing case in India, because my case lasted from 1945 to 1990. It lasted for 45 years. Incidentally. So I asked him, are you in the Guinness Book of World Records? No, he said, no. Guinness Book of World Records has said they will not have any entries on legal cases, especially if they concern India, but he will be happy to know I am in the Limca Book of Records. That record of 45 years, if you've been reading the newspapers, has recently been broken by a case in Calcutta, which went all the way up to the Supreme Court. It took 50 years. The third anecdote concerns a gentleman I met roughly at that time. His name was Lal Bihari. Lal Bihari was from UP. And Lal Bihari had an ancestral plot of land which was coveted by his maternal uncle. So the maternal uncle bribed the Tehsildar to declare Lal Bihari dead. So Lal Bihari fought a battle to establish that he was alive. He went and threw stones at the police station so that the cops would arrest him. He stood in the elections against the then Prime Minister. He did all kinds of things, but he could not establish he was alive. So finally, he did some research and discovered there were another 25,000 such dead men walking around in UP. So he found something called the Dead Man's Association, Mritak Sangh, and he changed his name to Lal Bihari Mritak. To cut that long story short, I wrote about it, this, that, and the other happened. Eventually, Lal Bihari got the Ig Nobel Prize. There's something called the Ig Nobel Prize. He got the Ig Nobel Prize for his strange pursuits. Eventually, he was declared alive. In the midst of COVID, there was a film called Kagaz, which is based on Lal Bihari's travails last year. It was released last year, early this year. Most of us, well, at least the three I can see on the screen, are economists. And economists talk about markets. But markets are not mandis. Markets are conceptual structures constructed by economists, and those markets exist in a certain social, historical context. And that institutional structure is set up by the legal system. I happen to think that the classical economists had a much better appreciation of the institutions that current economists do, despite the awarding of Nobel Prizes to economists who have specialized in institutional economics. And the legal system establishes or is a vital component of that infrastructure, that particular edifice. Comparing legal systems across the globe is very, very difficult because jurisdictions are different. Some of them are civil law systems, some of them are common law systems, all kinds of stuff. What kind of metric will you use to compare them? With all of those caveats, In the early 90s, the current reforms that we talk about, they were launched in 91. Soon after that, early 90s, a respectable organization did a very back of the envelope kind of cross-country comparison estimation and argued that if the legal system were to be overhauled, there would be an increment of 1 to 1.5% to India's GDP growth. These estimates, as I said, they are subject to all kinds of caveats, but nevertheless, they drive home the point that the legal system needs to be efficient. Insofar as the political economy of it is concerned, who drives reforms? Reforms since 1991 have primarily been driven by economic ministries. Some of the instances that I will give you about the legal system are in a way delinked from the 1991 economic reforms, because even if the 1991 economic reforms had not occurred, the legal system needed to be revamped, and I will give illustrations. But since 1991, by and large, not always, the legal system has been improved or reforms have happened only when there are WTO kind of obligations, intellectual property rights being an example of that, or alternatively when some sector is being opened up. Let's say physical infrastructure, let's say power. So there is an external catalyst which sort of drives the legal reforms, whereas there is an endogenous need, so to speak, for legal reforms, and I will give illustrations of that. That never seems to have taken off in the political economy of the process. And remember, of course, that when we mean the word law, we need to define the word law. At a certain level, when we use the word law, we are talking about statutory law. Statutory law means law that is passed by Parliament or passed by Legislative Assembly. And in India, though strictly speaking, legally speaking, it's not federal, essentially it's a federal country, so there are areas where the union government legislates, there are areas where the state government legislates. So on the statutory law part of it, there are three main issues of statutory law reform. The first one is eliminating and identifying old laws and repealing them. All laws that are dysfunctional, all laws that are outdated, and repeal them. I think this exercise should have been done in 1950 when we had the new constitution. It wasn't done in 1950. There was a perfunctory attempt to do this in 61. The only systematic attempt to do this happened after the Narendra Modi government came to power in May 2014 through 4 successive acts. About 1,700 old laws, many of which were colonial laws, they were junked. What difference does it make? An outdated piece of legislation is irrelevant. And by the way, the reason we have legislation that is outdated is in our legal system, we cannot have what lawyers call desuetude, which simply means that any particular statute is enacted for a certain period of time. At the end of 25 years or 30 years, whatever is the time period, the law dies a natural death, unless a fresh review decides that I need to have this particular statute. We don't have that, we cannot have that, let me not get into that. Other countries also have this. What's the harm? In London, taxis are still governed, or were governed until 4 years ago. I don't know what's happened now, by the Hackney Carriages Act. And the Hackney Carriages Act required that every taxi cab, which meant a horse-drawn one those days, needed to have enough hay for the horses. And taxis until 4 years ago were still governed by that. So they were supposed to carry hay. What difference does it make? No one is bothered, except that in India, such old laws can give rise to unwarranted harassment. Until recently, we had something called the Sarais Act of 1867. And the sarai, a sarai is the roadside well. And the Sarais Act of 1867 required that every sarai keeper should give a passerby a free drink of water. A hotel in Delhi, an important hotel in Delhi, was prosecuted because it was not giving passers-by free drinks of water. Eventually, better sense prevailed and the case was dropped. But the point I'm making is old laws are often used for harassment. For example, historically, Delhi is often invaded by locusts, or used to be invaded by locusts. Even today, the law in Delhi, the law applicable in Delhi says that if Delhi is invaded by locusts, the district magistrate will announce this through a beating of drums, and every able-bodied person must aid the administration in fighting the locusts. Arvind and I are not able-bodied, but Charan might very well be prosecuted under this act if Delhi were to be invaded by locusts. What is the oldest law in India? The oldest law in India goes back to the year 1836. It is called the Bengal Districts Act. It's still there on the statute books. It's a one-sentence act which allows the state of Bengal to create as many districts as it wants. There is no particular reason why you need a statute to do this, because all kinds of states are creating districts without resorting to statutes. So why is the Bengal Districts Act still there? Because I mentioned some old statutes had gone. The reason is, it is the view of the courts, the Supreme Court, that anything is on the state list post the Constitution, old laws can only be repealed by states. So I said about 1700 old statutes were repealed. About 256 are pending. They are pending a repeal because the repeal has to be done by states. But at a certain level, what I've talked about is very simple. Outright repeal of old laws. Because more often than not, the issue is you cannot repeal a statute outright. There is one particular section that you want to amend and repeal. Outright repeal is easy. At the stroke of a pen, you can repeal it. But if it is a question of repealing one particular section, you have to sit down with the statute section by section, identify. And this is a time-consuming exercise. An example of that, not possibly the best example, but an example of that is Asiatic power. What the hell is an Asiatic power? Who has defined it? But even today, the Indian Penal Code, which goes back to the year 1861, says that if a citizen of India does something that annoys an Asiatic power, that person is sort of guilty of a crime. Section 377 is another example of that. Section 69 of the Transfer of Property Act is another example of that. And remember what I said, that when we are talking about statutes, it can be union government or it can be state government. At the union government level, depending on how you count a statute, sorry, Arvind, were you saying something? Oh, the sound has gone. Can you hear me? Can you hear me?
We
I
can
can't
hear you.
Yes, yes, I can hear you. There was some noise here.
Okay, can you hear me now? When I say statute, it can be union government as well as state government. At the union government level, depending on how you count a statute, because depends on whether you're counting an amending statute or you're not counting an amending statute, there are around 1500 union government statutes. How many statutes are there at the state government level? And by the way, at the union government level, thanks to something called India Code, you have an inventory, electronic, on the net of all the union government level statutes. Let me now digress and talk about an experience, an anecdote from Rajasthan, when the then Chief Minister of Rajasthan wanted someone to take a look at all the laws in the state of Rajasthan. The bureaucracy advised her to set up a law commission. Her response was, if I set up a state level law commission, and by the way, several states do not have state level law commissions. Her response was, if I set up a law commission, nothing will get done. It will have endless meetings. I cannot afford to wait that long, so I'm going to set up a 2-person task force. So I chaired that task force, and there was an additional secretary. And the first question we naturally asked is, how many laws, as in statutes, are there in Rajasthan? And no one had the foggiest idea. Now, don't get me wrong, you will go walk into a lawyer's chambers and find volumes which say laws of Rajasthan. So the major ones, you know, I'm not talking about the major ones, I'm talking about all of it, the entire lot. So he sat down with the records of the state assembly, and we got a list of all the acts ever passed by the state assembly in Rajasthan. Sometimes there were laws passed from earlier pre-colonial days, sometimes laws passed by other states which were adopted by Rajasthan. And we had a list of about 950. Next, we wanted the texts of these statutes. And for about 50 statutes, the texts were not available anywhere, not even in the assembly, not even in the governor's office. So eventually, the additional chief secretary then had a brainwave. He and I visited the government printing press, because the government printing press always keeps copies. And from the government printing press, we resurrected the texts of the missing 50 statutes. So we had texts now of all 950 statutes, which gives you a rough idea, because I go back to the question I raised about 1500 union level statutes. How many statutes are there at the level of the state governments? The answer is no one knows. But if Rajasthan is an example, probably every major state has about 1000 statutes. And I repeat a point I made earlier. As a citizen, I'm supposed to know the law. So the law should be up there somewhere for me. For the union government, I will have all of it in India Code. One of the missing things that's still lacking in the Indian context is that all the state government laws, sometimes they are not in English or Hindi, they are in regional languages, they are not up there on the website. I don't mean the major ones, you'll get the major ones, but I mean all of them. So in Rajasthan, we set about this process, and the repealing part was easy. When you're going to repeal the entire law, that is easy. One stroke of the pen, we managed to do that, although we confronted the resistance. because those outside the government system may not always appreciate that every statute is administered by a certain department. And the department has a sense of ownership over that statute, so it refuses to let go. So strong arguments are articulated as to why you need the statute. One of the things that's not been attempted in India is a completely different kind of look at a statute. The question to ask is, why do I need this statute? What are the benefits that I'm going to get if I pass this statute? What are the costs of not having this statute to do what is called the cost-benefit analysis? A kind of legislative impact assessment. Ostensibly, the state of objects and reasons that comes with a bill is supposed to do this. But if you look at the statement of objects and reasons, you will find, at least this is my belief, that over a period of time, the quality of the statement of objects and bills, of objects and reasons in the bill has deteriorated. So today, the statement of objects and reasons that comes with a bill is very, very flimsy and perfunctory. And I think one of the necessary things to do now is, before any piece of legislation is passed, whether it is at the union government level or at the state government level, particularly keeping in mind the fact that the statute is going to be open-ended and not close-ended, is have a proper cost-benefit analysis, the likes of which has been done in some other countries. Anyway, so one of the biggest problems in Rajasthan was to persuade departments to let go. For a government like Rajasthan, which exemplifies what probably happens with other states also, the bulk of laws, I mentioned 950 laws, the bulk of them concerned land revenue, agriculture in one way or the other. So the next question that arises is rationalization and harmonization. Even if I need a statute, I need to rationalize and harmonize, because statutes are enacted at different points in time. They're enacted almost in silos. And therefore, over a period of time, definitions change, concepts change, and therefore a case law changes, causing further confusion. To give an example, earlier, the indirect tax structure before GST was such that the Supreme Court, the highest court of the land, has had to adjudicate whether green coconut was a vegetable. It has adjudicated whether haldi, turmeric, is a vegetable. In the green coconut case, there was a division. So the learned judges of the Supreme Court could not agree on whether green coconut was a vegetable or not. Why was this important? Because vegetables do not pay excise. By the same token, in the absence of rationalization and harmonization, the jurisprudence becomes much more complicated. So we have a situation where, until recently, under the law, labor laws is a good example of absence of rationalization, harmonization. Under labor laws, I did not know who was a workman. As you know, at least the union government laws has been codified under 4: social security, wages, safety, and industrial relations. There are about more than 50 of them. They have been codified, unified. But who's done this codification and unification? It's been done by Union Labour Ministry, which means Union Labour Ministry is only concerned with labour laws that are administered directly by Union Labour Ministry, which means 29 laws. Let me give an example to illustrate the point I'm making. is someone who's 17 years old allowed to work. As you know, under the law, we have free and compulsory education till the age of 14. So from the age of 14, that person is entitled to work. So person who's 17 is entitled to work. But if that person is entitled to work, that person must have some rights. But under the Trade Unions Act, no one can become a member of a trade union until the age of 18. So I'm just giving an example of a situation where we still do not have this rationalization and harmonization. In the Rajasthan case, we did the rationalization and the harmonization. But there's still a question that is a perennial question, and let me flag that. And this is an ideological question, which is what should the government be doing and what should the government not be doing? An example of that is the Boating Regulation Act from Rajasthan, which allows the government to effectively license and regulate boats. Should the government be doing that? As I said, this is an ideological issue about the role of the state, which, as an economist, I would say, as a society, we have still not decided, failing which we cannot take a position on what a government should do and what a government should not do. To conclude the Rajasthan story, as a result of all this, despite the Boating Regulation Act continuing, we reduced the number of statutes from 950 to about 150, all of which were up there on the net. And obviously, when a statute is unified, the administrative law is also unified. Since I've mentioned administrative law, let me give you another anecdote. Arvind, I can no longer see Arvind, but there was someone from the civil services who became a great economist subsequently, Gohan. I once met Gohan, and Gohan told me, listen, let me tell you, since you are interested in the law, let me tell you about what happened in Tamil Nadu. So I said, what happened in Tamil Nadu? There was a Tamil Nadu Administrative Reforms Commission in the early 80s. And amongst other things, this Administrative Reforms Commission was supposed to identify surplus government jobs and recommend their abolition. When it began to do this, it discovered that there were two kinds of jobs called LBA and LBK. LBA and LBK, and no one had the foggiest idea what LBAs and LBKs were supposed to do because they're all retired and were drawing pensions. So these LBAs and LBKs who had retired were summoned to explain to the Administrative Reforms Commission what their job profile was. And the story emerged. In the year 1936, there was a famine commission. It was not exactly a famine commission. Technically, it was called an Agricultural Reforms Commission, which, by the way, amongst other things, recommended the MSP. But anyway, it was an Agricultural Reforms Commission, and the chairman of that Agricultural Reforms Commission was Lord Linlithgow. Like most commissions, no one paid the slightest bit of attention to the recommendations of the commission. And one of the recommendations was that Indian cows are inferior as a species. So you should import foreign bulls, use them to impregnate the Indian cows so that the Indian cows became more productive and improved as a species. As happens with any government commission, no one paid the slightest bit of attention to the recommendations of this. Until suddenly it was announced that Lord Linlithgow had become the new Viceroy cum Governor General. So one gentleman in the civil services in what was then Madras Presidency woke up and concluded correctly that as soon as the new Viceroy arrives, he's going to ask, what happened to my recommendations? and he decided to implement this bit about the bulls and the cows. In the government, abolishing a job is difficult, creating a job is also difficult. So he decided to create these jobs by invoking the Viceroy's name in the job title itself. So LBK stood for Linlithgow's Bull Assistant, LBK stood for Linlithgow's Bull Keeper. So the bull keeper imported the bulls, and because there was a subsidy involved, the LBA, the Linlithgow Bull Assistant, was supposed to ensure that the impregnation happened at the right time. So as I said, these bulls that were created in 1936 were abolished in the mid-1980s. When I heard this, I began to laugh. So Dr. Goran told me, don't laugh. We couldn't do anything about CCA. So I said, what is CCA? He said, CCA stands for Churchill Cigar Assistant. I said, I've never heard of it. He said, well, look, Churchill was fond of Havana cigars. World War II disrupted it. And someone figured out that cheroots from Trichy were a convenient substitute. So this government post was created, Churchill Cigar Assistant, to supply these things to Churchill, and the system went on and on. Anyway, the point of this is when you talk often about discretion, bribery, corruption, sometimes it's not the statutory law, more often than not, it is the administrative law. And whenever the administrative law is amenable to discretionary interpretation, it provides an avenue for corruption, harassment, bribery, rent seeking. And therefore, it is important to take care of the administrative law also. And when I say administrative law, I do not only mean G to B relationships. I do not only mean G to G relationships. I also mean G to G relationships. So let us not lose sight of the fact that the administrative law reform is an important ingredient of law reform. Let me now turn to the last one, which is the speed of dispute resolution. The legal system is supposed to punish mala fide intent, and it is supposed to protect bona fide intent. Unless it does so efficiently, unless it does so fast, it does not facilitate decision making, including economic decision making. It does not facilitate growth, productivity. As economists, we will talk about factor markets, land, labor, capital. All three, to a greater or lesser degree, are plagued by legislation, inefficient legislation. If I look at the number of cases pending in India, depending on how you count cases, depending on how you count courts, depending on how you define courts, depending on whether you're going to include tribunals or not include tribunals, there are about 40 million cases pending. About 40 million. Some of which are as old as are 50 years old. The example I gave you. Several of whom are 10 years old. About 2/3 of these are criminal cases. About 1/3 is civil cases. The criminal cases are concentrated in the lower courts. The civil cases are concentrated in high courts, and of course, therefore, you have the Supreme Court. There is a long list of things you can do or you should be doing to reform the system. Unfortunately, the system has been reformed only very, very imperfectly. When the Civil Procedure Code amendment was passed in 2001-2002, it was expected that the average civil case, unless land was involved, would be sorted out in 1.5 years. It has not happened. On the criminal side, we have the Criminal Procedure Code, we have the Indian Evidence Act, we have a host of other laws. And also on the criminal side, the moment you talk about criminal justice, you cannot but talk about police reform. And since the Prakash Singh judgment of 1996, police reforms have been stagnant and stagnating. Every now and then from the lawyer, from the judiciary and even from the lawyers, you will hear the response, let's have more judges, let's have more courts, let's have more benches, as if that will solve the problem. I think other than Charan and Arvind, no one else here remembers Say's law. In a perverse application of Say's law, the supply has created its own demand. So there have been instances of more courts, more benches, etc., but all that has happened is it seems to have stimulated demand, and essentially the average citizen is being crowded out of the court system. So in that sense, the best statement of that, and I can do no better than that, is Sunny Deol in Damini, Tariq Pe Tariq. And I think it is important to flag the speed of dispute resolution. There have been alternative forums, arbitration, conciliation, mediation, all of that, fast track courts, various other things. But all said and done, the speed of dispute resolution is also critical. Thank you very much.
Thank you, Bibek. I'm here. I guess can you see me? You said I disappeared.
Yes, you have migrated from the west to the northeast.
Yeah, maybe it's moved. Okay. Charan, how much time do we have? Should we take a few questions?
Yes, sure.
Yeah, sure.
I know the answers.
Okay. Let's see. Okay, Dr. Vishandas, Professor Ashok Vishandas.
Yes, sir. Sir, we are Bibek Debroy. We are delighted to hear your view. We recently heard and read your article in Hindu on this land reforms also, and one particular case you illustrated of one lady in the West Bengal that we know. Now it's very interesting. The more code you created, and the more demand for such things, and there is a perceived perception among the masses that these judges or the lawyers are in collision to give to give adjournment, and that is one of the main reasons for this. And at the end of the round, this causes a lot of duress to the petitioner. And how you what is the way out that speedy justice is ensured, and what is the way out for the government? You have given very wonderful perspective and on this thing, but solution is still eluding, even just for the because I have served 35 years in the government, and there are many cases. Even the CAT, when the Central Administrative Tribunal was established, it was with the intention that the government officers grievance will be redressed very quickly. Now they are also flooded with so many cases. So what is the way out?
That's a good question. I would have preferred to treat it as a comment. By the way, it was not the Hindu, it was a different newspaper, but let that pass. You see, that question requires a very long answer. Stated simply, there are some supply side measures one can take, including productivity enhancements. Every organization has productivity norms. Productivity norms should emanate from within the system. Productivity norms are not acceptable if they are thrust on the system from outside. There have been metrics that have been suggested, and there are two excellent organizations that do work on law now. One is Daksh and the other one is Vidhi. They have suggested metrics to measure productivity. Unfortunately, the judiciary is extremely reluctant to accept any norms of productivity. I have not mentioned the use of simple language, plain language. We are in a situation where a judgment given by a court in Himachal was sent back by the Supreme Court because the judges of the Supreme Court said, we do not understand what this judge has said. It's in English, it is not in an alien language, but you cannot understand what the judge has said. So I should mention the plain English movement, which has left drafting and law and the drafting of judgments completely untouched. I mentioned legislative impact assessment. By the same token, there should be a judicial impact assessment also. The second bit is improving the procedures, which I indirectly touched upon when I mentioned the Civil Procedure Code, the Criminal Procedure Code, the Indian Evidence Act. Those enable a judge to exercise the right not to grant an adjournment. It is a different matter that very few judges exercise that. And lest I be accused, lest I be prosecuted under the Contempt of Courts Act of 1971, let me quote Mar Gallanter and say that today the judiciary has been captured by the bar, which is what you were alluding to. And finally, there is the demand side and all kinds of measures on the demand side. There are several law commission reports, there are several committees set up by the Supreme Court, High Courts, and best of all, you can read the report of Judge Rankin. I think he was from Calcutta High Court, who submitted a report in the year 1924-25. If you read Judge Rankin's report, everything that you can do to solve the system is there in Judge Rankin's report.
Right, sir. Thank you.
Thank you. Yeah, that's very good. Dr. Charan Singh, you have a question?
I had a few questions. Firstly, I must mention it. I've never seen such a brilliant talk on law and economics. The style of anecdotes and that drives home the point so forcefully, and then drawing your conclusions from it. Thank you very much. Makes it so interesting and also is very, very forceful. So I like the way you mentioned about Rajasthan. So my first question is, other than Rajasthan, having set an example there, have other states followed it? And if so, what has been the state of other states? What is the status in other states? The second is, because you are an economist, we are economists, I'm sure your mind and the way you told your journey starting in 93, how it all happened, you're a hardcore economist. So as an economist, the first thought is, what is the cost of these delays that take place? 50 years, 45 years, 25 years is a very standard thing in legal parlance. So what are these cases which involve commercial um, costs, and any estimates done on what is the implication on the economy of such delays? And the last question I have is, you have seen what has happened in the banking sector. The government has brought in time-bound judgment has to be provided. NCLT, IBA, IBC, time-bound. And within 270 days, this side or that side. And you have a chance of appeal, and even after appeal, maximum 360 days, you have to do it. So is there a possibility, and that also links with the Professor Vishanda's question, is there a possibility that we learn something from the West or from our own courts in commercial banking areas, and we have a time-bound legal system. Thank you.
Mm. You see, I am not aware of any state which did what the Rajasthan Chief Minister did, which is to just sort of set up an ad hoc two-person task force. There are states which have set up law commissions at various points in time. The two obvious examples of that are Kerala. Three obvious examples of that are Kerala, Tamil Nadu, and Rajasthan. So these are the only three, but some of them are of old vintage. So yes, I do think states need to set up these law commissions. But to state the obvious, such a thing is perceived as important only when the chief minister regards it as important. Otherwise, there are no takers for law reforms until the chief minister herself or himself decides to drive it. So far as the quantification is concerned, this is, as you will appreciate, it's very difficult to quantify, except back of the envelope. The only attempted quantification, which I can mention with several question marks, is what the World Bank does in its ease of doing business, which is restricted often to questionnaires. Generally, this particular metric is restricted to questionnaires done in Mumbai and Delhi. And it tries to estimate time overruns and cost overruns. However, I will paraphrase and quote what Justice Venkatachalaya, ex-Chief Justice of the Supreme Court, once told me. And there is a grain of truth in what he said. At that time, the number of cases pending was around 35 million when he mentioned this to me. He said, Bibek, for simplicity's sake, let us assume there are two litigants on both sides, which is true, of course, of civil cases. Criminal cases not necessarily true, but for back of the envelope purposes, that is absolutely fine because the civil side may have more than two litigants also. So, two litigants, 35 million into 2, 70 million. So he said, look, 1/3 of the households in India are litigating. So when you as an economist complain to me about it, I look at it and say that 1/3 of the households still have faith in the judicial system. That is the reason they are litigating and are not doing the kind of things that were highlighted in the angry young man kind of films of Bollywood in the 70s when you look for other alternative sources. So 1/3 of India's citizens still have faith in the legal system, even though they are cynical about the other two organs of state, they still have some faith. In terms of the timelines will never be accepted by the judiciary. And in the case of the IBC, there are timelines that are specified, but those timelines are violated. Not by a great deal, they're violated because the belief of the judiciary is, and I'm quoting the late Justice Krishna Iyer, justice hurried is justice buried. So the judiciary, in the interest of natural justice, tends to bend over backwards. However, I will mention this, partly a reaction to what Ashok said, that at the union government level, there was an exercise that was not meant for public consumption and public dissemination called LIMS. LIMS tracks union government cases. Instances where union government, as in union government ministries, are involved, including service matters, and it is a database to enable better decision making, to ensure that there aren't pointless appeals when you've lost at courts down below. And LIMS has been, it is restricted in scope, but it has been phenomenally successful. But to come back, and it should be replicated in other states, but to come back to Charan's question, this is the kind of situation where essentially what we are saying is you need a metric that needs to be accepted. And I repeat, the metric cannot come from outside, the metric should emanate from inside. And after all, every reform happens because we as citizens indirectly want that reform. And I do not see that pressure yet building up. To give an example of that, I work in a certain organization. Forget the actual organization I'm employed in now, but I work in X organization. I'm entitled to a certain number of days of leave a year. So I go on leave. Does that mean the entire organization shuts down during that period? No. I go on leave, someone else works. Have you heard of any organization in India where the organization entirely shuts down during a vacation because people are going on leave? Even schools, colleges, and universities don't do that. Students may have holidays, but the staff do work. The holidays are rotated. As far as I know, there's only one organization in India which still has this system of vacation. That, of course, is the Supreme Court. But, as I said, do I see that pressure emanating from civil society? No, I don't. The timelines are only one metric. A similar metric can be the unnecessary appeals. The US Supreme Court does not admit more than about 10% of cases that come before it. I would recommend everyone who's not familiar with the work of Vidhi and Daksh to look at the work of Vidhi and Daksh. Vidhi and Daksh have been arguing that, look, just as academic, these are not their words, I'm using my words. We have recognized in academic institutions now that an academic is not necessarily best equipped to perform managerial tasks and administrative tasks. So let us bring in someone to manage who's better equipped and let the academic be free to teach. Exactly similarly, insofar as the judiciary is concerned, why do we not bring professional management to the management of the court system and leave the judiciary to do what they are good at, which is deliver judgments? So there has been a lot of work, particularly in the last 5 or 6 years, done by Vidhi and Daksh, especially on the Supreme Court.
Just one preliminary question. We heard about the argumentative Indian. I wanted to check with you whether do you have statistics, which is the most litigating segment of Indian society? Is it the Punjabis or is it the Bengalis? Which high court per capita would have the highest number of stuck cases of this 40 million?
No. Look. That's easy to answer, but do not link it to linguistic or cultural stereotypes. For example, UP is a large state. It has, everyone will argue that UP requires a second bench of the High Court. Unfortunately, we have still not been able to agree after years and years where that second bench should be. If you are talking about the number of cases that are stuck
Per thousand population.
Yeah, can't reel off the numbers offhand, and depends on whether you're talking about high courts or lower courts, but all those numbers exist. And UP, Tamil Nadu, West Bengal would be right at the top of the list. But those numbers readily exist.
Probably, my thought was that those are the states which need the task force immediately. Maybe those are the places where laws are too archaic and therefore the attention has to go there. And I was looking at it from the angle of the economy, that are those states getting blocked, and that is where the economic.
No, Charan, let me say this. The 13th Finance Commission, as you probably know, the Finance Commission had granted sums of money to for setting up of fast track courts. For the 13th Finance Commission, Dr. Kelkar had asked me to write a paper on what should be the focus. And I had argued that instead of scattering money across the board, across all states, you should focus on states which had a high backlog, high concentration of old cases, and give money only to those. That's not the important point. The important point is that paper, which was a public paper written for the 13th Finance Commission, will be there on the 13th Finance Commission's website. That gives the figures you are asking for, although it's a little bit dated, but it'll give you some idea.
Okay. Yeah, thank you. So one question I have, I don't know whether you have the data, but it used to be argued earlier, some time ago, that government is responsible for huge numbers of cases. Do you have any comparative picture of what's the trend? I mean, is that going down? Is it more or less the same? Or anything, information you have on that?
The data that exists, by the way, if it is a criminal case, obviously the government will be involved. We are not talking about criminal cases. The cases we are talking about are civil cases. For civil cases at the high court level, I repeat, at the high court level, the government is a litigant in about 45% of those cases. The earlier figure that used to float around on the basis of a sample survey that was done in Karnataka in the mid 1990s was 60%. It's not 60%, it's about 40%. But the union government LIMS exercise is meant to address particularly also these kinds of things, because sometimes the government interpreted as a government, it might be a PSU also, is sometimes litigating on both sides.
Yeah. Okay. Charan, sorry, I interrupted you. You have another question?
No, I think it was very, very knowledgeable for us, big
Okay.
learning for all of us.
Right. So I don't see any questions on the chat. Okay. So with that, let me thank Dr. Debroy and conclude the session and hand it to you, Charan, to conclude the proceedings.
So thank you very much, Professor Debroy. This was really interesting. And for many of us economists, I think this is the first time we have heard something to do with law and economics. And listening to you, it is becoming so apparent that how these 40 million cases could have locked up lots of economic power, and thoughts keep pouring in. And as Dr. Virmani was saying, if government is the litigant on one side, probably these are environmental cases where these need to be sorted out. And computing cost of these sort of cases is so difficult and challenging. So we totally agree with you when you said that costing of these cases is not being done. Because the methodology of computing cost, even the costing per se, is a challenge in these cases. However, it does show that the reforms in the legal aspects of India's growth need to be done. You have set an excellent example in Rajasthan and shared with us. We will be also now onwards thinking about this, and wherever we get a chance as a policy think tank, mentioned that they need to reform their legal system. At least the laws need to be revisited. And the drastic changes that you did in Rajasthan from 950 laws to something like 150 shows that how much of flab exists at other places. So thank you very much for teaching us such important things which we as economists tend to ignore all the time. I want to thank all the participants. Today was the first time we experimented with this time slot. I'm so happy to say 90 participants were sitting with us almost throughout, and even now there's 83 participants sitting with us. So I think we are experimenting with different time slots, and this was very encouraging. We could even try this in future. The recording of today's presentation will be available by noon tomorrow, and I'm sure all of us are going to use it extensively and making use of this even in our classrooms, because as an economist, we should know what the law does for us. The next week, we have an important discussion. A book has just been released on Punjab, which has numerous chapters on the economy of Punjab. The book is concentrated on economy of Punjab, and the focus is on COVID and post-COVID recovery in Punjab. Though the book is on Punjab, it's been written by a different economist. It's an edited book, and the editors, one of them is Sukhpal Singh from IIM Ahmedabad. The other is Professor Lakhvinder Singh Gill from Punjab University, Patiala. They'll be here. They'll be here next week to discuss about their book. I would welcome all of you to be there so that we know what they are thinking in terms of post-recovery Punjab. And they've discussed about commercial banking, MSMEs, agriculture, industry, whole lot of things which go with post-recovery. Would welcome you for the session next week. So once again, let me thank our chairman, Dr. Virmani, to have chaired the session and spared this time for us. Our guest and speaker, Dr. Bibek Debroy, and the participants for being with us. I'm sorry we have exceeded by about 13 minutes, but I think the discussion was so interesting and so much informative. We had to dig deeper and get the best out of the time that we had from chairman of the Prime Minister's. Thank you.